The second clause of the First Amendment says, or prohibit free exercise thereof. So we have to now consider that portion of the First Amendment that deals with freedom of religion. If in previous lectures we considered the Establishment Clause, Congress shall make no law respecting an establishment of religion, in this lecture we're considering the part that says, or prohibiting free exercise thereof. So we know that a state may not punish people for holding or rejecting certain beliefs. However, the exercise of individual freedom takes place in a larger community. So we may believe whatever we want to believe, but once we act on our beliefs, then our actions eventually will run up against the beliefs of others and against the interests of the community as a whole. So the question becomes, at what point should a claim to free exercise of religion excuse practices that clash with interests of the community? We begin with the earliest cases considered by the Supreme Court, Reynolds versus Sims and Davis versus Beeson. Both cases dealt with LDS, Church of Latter-day Saints, or Mormons, colloquially known. The first came out of Utah, the second came out of Idaho. Both of these places were not yet states when these cases reached the Supreme Court. Utah and Idaho were still federal territories at the time these cases took place, and that's important because that means that these cases could be considered by federal courts without the issue of the Free Exercise Clause first being incorporated, that is to say, applied to states. So in Reynolds versus United States, the court decided the constitutionality of statute that prohibited polygamy in the territories. Reynolds was assistant to Brigham Young, who was at the time the leader of the LDS Church, and he challenged this federal statute that prohibited polygamy, and he lost. The Supreme Court unanimously said that one can hold whatever religious beliefs one wants, but it doesn't excuse criminal action. So a strict separation here between criminal action and religious beliefs, a very clear conduct-belief distinction. Your conduct is completely separate from your beliefs. Believe whatever you want, but then you cannot use your beliefs to justify conduct which is prohibited by criminal law. Davis versus Beeson dealt with an Idaho territorial law that required people to swear an oath that they did not belong to any sect that practiced polygamy and were not themselves members or advisors or counselors of such a sect. Now, in this particular case, the man was convicted of swearing a false oath. He swore he did not belong to such a sect, and he did, and so he was convicted. In this particular case, Justice Field spoke very harshly of the Mormon religion because he said that to consider polygamy a practice, a legitimate practice of religion, is to offend the common sense of mankind. So short shrift was given here to claims of religious liberty. This is kind of, both of these cases are the low watermark of religious protection. No protection really is given for religious exercise here in these two early cases. Then we have this very interesting case of Lukumi Babaluai versus City of Hialeah. I will explain why I jump all the way from the late 19th century to the late 20th century. You see, the thing is that in both of those cases, Reynolds versus United States and Davis versus Beeson, what ultimately allowed those territorial laws to stand, to be upheld as constitutional, was the fact that they did not target Mormons by name. They did not specifically target them. The laws said that polygamy is unlawful. It didn't say that polygamy is unlawful only for Mormons. It said polygamy is unlawful, period. So when you have a law that's general in application like this, it's called a formally neutral law. And the courts have held that if a law is formally neutral, then religious defense doesn't work. And it's interesting that in Lukumi Babaluai versus the city of Hialeah, we had what on the surface seemed to be a formally neutral law that applied to everyone, but the court said it was not neutral. The Church of Lukumi Babaluai practiced Santeria religion, which is a mix of Roman Catholicism and Voodoo African rituals. And the church acquired land in the city of Hialeah in Florida. And the problem that the city of Hialeah had was that Santeria religion actually practices animal sacrifice. They kill goats, pigeons, turtles, and usually eat them afterward. So the city of Hialeah, in a midnight session, its city council passed an ordinance that said that animals cannot be killed on purpose except by licensed butchers. So this particular attempt was a last-ditch attempt to prevent the Church of Lukumi Babaluai from moving into the city. Even though the language of this ordinance seemed neutral, not just seemed neutral, but really was neutral, the Supreme Court said that the totality of the circumstances was such that it was clear that the City Council of Hialeah specifically targeted this Lukumi Babaluai Santeria Church in order to drive it out, or in order to prevent it from ever setting up in town. And so the ordinance was overturned. Hialeah lost, and Lukumi Babaluai won. Cantwell versus Connecticut was an important case because it incorporated the free exercise clause. It applied it to the states. Sherbert versus Werner was a very interesting case. In this case, Adele Sherbert refused to work on a Saturday in a private factory in South Carolina, and she was let go. She was fired because she refused to work, and she went to get her unemployment benefits, and the unemployment office denied her benefits. She said, well, you know what, why are you denying me benefits? And they said, because you were terminated for a cause. You refused to work. It's not like you were laid off. It's not like you wanted to work. It's just that you didn't want to work, so you're not eligible for unemployment benefits. And she said, wait a second, I was refusing to work because of my religion. I'm a Seventh-day Adventist, and I'm not supposed to work on a Saturday. And they basically said, we don't care, and they denied her unemployment benefits. But the Supreme Court said the unemployment office acted unconstitutionally. It should have accommodated Adele Sherbert by giving her unemployment benefits. The Supreme Court said that there was no compelling state interest which justified such a substantial burden on Adele Sherbert's First Amendment right, which includes the right to exercise her religion. So I have to point out here an important fact of constitutional theory. This important fact is that when you talk about fundamental rights, such as freedom of religion, freedom of speech, they can be limited, in fact, if government has a compelling purpose, and if the means that it uses are narrowly tailored to that purpose. But in this particular case, the court said there was no compelling purpose for the unemployment office to deny her unemployment benefits. She should have been accommodated. Remember, this is not, as far as the Supreme Court is concerned, not a conflict between the private factory and Sherbert. It's a conflict between Sherbert and the unemployment office, because the factory was a private factory and therefore not subjected to the First Amendment. The First Amendment, just as the Constitution as a whole, does not limit what private individuals can do. It limits what the government can do. Wisconsin versus Yoder, in this case, Jonas Yoder and Wallace Miller, both members of the Old Order Amish religion, and Aiden Yahtzee, a member of the conservative Amish Mennonite Church, were prosecuted under Wisconsin law that required all children to attend public schools until age 16. You probably all have heard about the Amish, but not all Amish are the same. Some are even more conservative than others. And here you have a particularly conservative variation of the Amish, and they refuse to send their children to school after age 14. In fact, they say 14 and then we take them out of school because we don't want them to be exposed to the subjects and the worldviews that conflict with our own religion. And Wisconsin had a law which criminally punished parents or guardians who kept their children out of school before they were 16 years old. And in this particular case, they were fined, the parents were fined, and they sued, and the Supreme Court of the United States ruled in their favor. The Supreme Court said that there was no compelling purpose here on the part of the state to require 2 additional years of education. What is the purpose of education? Well, it's to create citizens who are basically good citizens, law-abiding citizens, who are economically self-sufficient. And the court said, look, the Amish, they commit almost no crime. They are not economically dependent on others. In fact, they reject welfare as a matter of principle. They simply will not accept it even if you give it to them. So what's the problem? If they do not want to send their children to school after they're 14, 16, what difference does it make if they reach the same result? Because even after they're age 14, their parents or guardians still give them vocational training, the kind of training that prepares them to be a carpenter or a ditch digger or whatever. So there's no compelling purpose here. And the court has also said that parents have a parental right to privacy. I know we haven't considered the right to privacy yet, but the court said that the parents also have a parental right to privacy to raise children in accordance with their wishes. And for this reason, the state of Wisconsin lost and Yoder won. Employment Division versus Smith overturned Adele Sherbert versus Werner. In Employment Division versus Smith, Native American drug counselors working for a private drug rehab clinic were fired because they were arrested for smoking peyote off the job. And smoking peyote was against the law of the state of Oregon. So for this violation, they were fired by the drug rehab clinic. They went to get unemployment benefits and they were denied because the unemployment office said that they were terminated for cause, so they were not eligible. They sued, claiming that their First Amendment right to free exercise of religion was violated when the unemployment office denied them unemployment benefits because they were in fact smoking peyote as a part of their Native American religious ceremony. So the Supreme Court, in this case, ruled against Smith and in favor of Employment Division, stating that this is just ordinary criminal law, and you cannot use your religious beliefs to get exempted from criminal law. So Justice Scalia wrote that the court has never held that an individual's religious beliefs excuse him from compliance with an otherwise valid law prohibiting conduct that government is free to regulate. But this is not accurate because I just talked about Wisconsin versus Yoder. That case was in fact a criminal case. But perhaps what Scalia meant here was the court never held that you can use your religious beliefs alone to get a waiver, essentially, from the law, to escape from the law. Because in Wisconsin versus Yoder, there was a second argument that parents could raise their children in essentially any way they wanted to. So Scalia went on to say that allowing exceptions to every state law or regulation that affects religion would open the prospect of constitutionally required exemptions from legal obligations of almost any conceivable kind. So whatever the burden is, whatever legal burden is that you have to comply with, you could always say, I can't do it because it's against my religion. This is what Scalia is saying. You can't do that. More importantly, the court made this formulation. And here I come back to formally neutral laws. The court in Employment Division versus Smith said that if the law is formally neutral, then the state does not need to have a compelling purpose in order to have a constitutional law. So what kind of purpose should it have? A reasonable purpose. Any reasonable, that is to say, any not insane purpose would suffice, would be fine. So this is an important formulation. Congress actually passed a law following this in 1993 called Religious Freedom Restoration Act, which said that in fact states and the federal government are required to have a compelling purpose if they want to limit freedom of religion. But several years later, in City of Bourne versus Flores, the Supreme Court said that a portion of the Religious Freedom Restoration Act is in fact unconstitutional. The portion that applies to the states is unconstitutional because while the federal government can pass a law limiting its own conduct, Congress cannot pass a law that overrides the interpretation of the Supreme Court. So the Supreme Court interpreted the Free Exercise Clause to mean as giving protection, however, not giving protection if the state law is formally neutral. So a portion of the Religious Freedom Restoration Act was held unconstitutional in City of Bourne versus Flores. And that's the current state of things as far as the Free Exercise Clause is concerned.